we will be able to take this issue with the two foreign legal experts that's joining us from the U.S. and Hong Kong. Joel Trachtman, Professor of International Law at the Fletcher School of Law and Diplomacy, and Bryan Mercurio, Professor of the Chinese University of Hong Kong. They are joining us via Skype right now. Hello, gentlemen.
Oh, thanks for having me on the show.
Thank you for having me. Always a pleasure.
Well, thank you so much for making time for us. First question for you, Professor Trachtman. South Korea decided to file a WTO complaint against Japan. Do you agree with Seoul's stance that Tokyo violated tariffs and trade regulations?
The Korean complaint against Japan is that Japan is denying bulk licenses and imposing other administrative burdens with respect to three kinds of chemicals that are used in smartphones and TV displays and semiconductors. And those burdens, that denial of bulk licenses, might violate the WTO General Agreement on Tariffs and Trade requirement for most favored nation non-discrimination. So if Japan is treating other countries better than it's treating Korea, it might be violating that Article 1. And that's one of the things that Korea has claimed. Presumably the rationale is national security, and there's a special exception in GATT, in Article 21 of GATT, for measures that are justified for national security reasons. But they have to be necessary to protect the state's essential security interests, and those are usually very strong security interests. And I'm not sure that this satisfies that. And it also has to be a position that's taken in good faith, and in good faith relating to security. And so if Japan is taking this action for purposes of retaliating against South Korea, because of the comfort women issue, then it probably is not good faith as a security-based measure. So it may not qualify for that security exception. And so I think it may be that a WTO panel would decide that Japan is violating WTO law and does not qualify for that security exception.
And turning to you, Professor Mercurio, Japan's export curbs justification, security reasons. The only time the WTO allowed a nation to use trade measures for safety purpose was a case between Russia and Ukraine. Based on such track records, what are Tokyo's chances?
Yes, it's a good question. When a WTO complainant has made out its case and proven that there's a violation of the norms and standard, the respondent, in this case Japan, can raise a defense. And here the defense which Japan will rely upon is Article 21. And Article 21 is the national security defense. This clause has laid dormant for decades. It has not been tested until recently in a WTO panel. It rose to prominence really in the last few years with Donald Trump in the United States referring to the provision when it took safeguard measures against steel and aluminium. Now, our recent WTO case is a panel decision. It was not appealed to the appellate body, but it was a very distinguished panel, probably intentionally so, because the WTO recognized the importance of this case, where Russia relied on the national security exception in a defense and a claim brought by the Ukraine. Now, Russia claimed and was backed by the United States that Article 21 is self-judging. That is, that a panel does not have the authority to rule upon it, and if a respondent raises a national security exception, it must be accepted. Now, the panel took a different view. The panel looked at the language, in particular of Article 21b(3), which states that a member may take action which it considers necessary for the protection of security interests, essential security interests, taken in times of war or other emergency relations. And the debate there became, what is an other emergency relation? And the panel held that there was a standard. Right? It said simple political or economic differences will not suffice. there needs to be a case of armed conflict, for instance, heightened tensions or crisis or general instability. And to be fair, I think if Japan can prove that there is diversion or risk of diversion of chemicals which can be used in the manufacture of weapons, that it would have a case of a legitimate justification. So really, it's fact dependent. I can't give an answer right now whether Japan's use of national security, the national security exception, is legitimate, because I think it's really dependent on the facts of the case. Is there a real risk of diversion? Were there problems with Korea's regime? What are those problems? Has there been cases of diversion? If Japan can prove with solid evidence that there is a risk or there have been chemicals that have been diverted to North Korea, then I think their case for a national security exception becomes stronger, because of course not only do we know the tensions between North Korea and South Korea, but also I think North Korea is a legitimate threat to Japan. So again, the case becomes stronger, but we'll have to wait and see what evidence is put forward to support the claim.
Professor Trachtman, as you know, the Korea has won the most of WTO dispute case with Japan. So how do you predict that a ruling with a specific lawsuit?
Well, it really depends on the way that the panel and maybe an appellate body would look at it. As you may know, the United States has not been agreeing to the appointment of new appellate body members. So the appellate body will stop working in December. So this case, which South Korea has brought against Japan, may not continue to the end where South Korea would be authorized to retaliate. So the precedent of who has won in the past doesn't really tell us who will win in a particular case. I think that if this case is pursued, it's probably more likely that South Korea would win, but it will take a couple of years at least to finish, and it may never finish unless the appellate body is continued.
Our final question is for Professor Mercurio. What about you? How do you expect this lawsuit to turn out?
Yes, again, I think that in this case, we'll have to wait and see what evidence is put forward. Now, Korea has taken really what I would call a shotgun approach to its claims. It has filed over 10 different claims involving 5 different agreements. Now, in the WTO, all you need is one to be successful to win the case. As I mentioned, I think that Korea's strongest claims are on the GATT, Article 1, Most Favored Nation, and Article 10, talking about the restrictions on exports. Its claims relating to the TRIMs, the Trade Facilitation Agreement, the Intellectual Property Agreement, and the Services Agreement are probably less likely to succeed. And that would mean that the case would hinge upon Japan's defense. And again, it's difficult to predict the likelihood of that without seeing the evidence that Japan is putting forward. If Japan can prove that there is a legitimate risk of diversion of these chemicals to North Korea and that the chemicals can be used to make weapons, or if it can demonstrate that actual diversion has taken place, its claim under Article 21 B3 is a lot stronger. I think in that case, their exception would be deemed to be legitimate, and they would ultimately win the case. So really, like with most WTO cases, it's fact dependent, and we'll have to take a wait and see approach before we can pass judgment on the merits of Japan's defense.